Good afternoon, and we are wrapping up our discussion about MMI and what happens at MMI, and we've talked about you've been given restrictions, you've been given an impairment rating, you've been given maybe a recommendation for maintenance care. What happens next? So my name is Britton Morrell. I'm with Kaplan Morrell. We're attorneys who have been helping injured and disabled workers here in Colorado since 1995. And as our own firm since 1997. And today I'd like to talk again about one of the biggest events or times of a injured worker's case, other than obviously when they get injured, and that is what happens at MMI. Okay, so the doctor has said you're done. The doctor has discharged you. The doctor has given you restrictions. What now? So there's a lot of stuff going on, and that's why you need somebody who kind of handles this, understands what's going on in order to be able to let you know what things to do. So first thing is, if you have a recommendation for maintenance care, continue to do the maintenance care. Number two, let's talk about work. What happens if you can work or not? If you're able to work, if you are at work at MMI, great, no worries, no problems, okay? Keep working, keep doing that. If you're doing modified work, you need to have that conversation with your employer about, hey, can I keep doing this modified work? Is there another job that I can do that I can do within my restrictions that's open and available? Do what you need to do to be able to keep working and keep food coming on the table and a roof over your family's head. That's most important. And we can talk later about a lot of the issues that happen when people get injured on the job and about accommodating them. But if you can work, do it. And if you're off work because of the work injury and now you're at MMI, you need to wait for a piece of paper called a Final Admission of Liability. And at that time, then you'll need to apply for unemployment. You can't necessarily apply for unemployment while you're getting wage loss under workers' compensation. So it's typically going to be best to wait until you get the final admission. What's the final admission, you ask? Okay, so after all of that is done, after the MMI, the impairment rating, the restrictions, etc., the insurance company is going to get that report from the doctor, and the insurance company has 30 days to decide whether or not they're going to admit to what the doctor says, or maybe they disagree with it. Maybe the doctor has given you such a high impairment rating that the insurance company doesn't like what their own doctor says. Maybe the insurance company doesn't like the fact that the doctor included a body part in your impairment rating or in the treatment recommendations. Insurance company doesn't think that it should be included. So sometimes the insurance company may decide to fight what their own doctor says. 80% of the time, in our experience, the insurance company files this paper. It's called a Final Admission of Liability. We've got videos about it, and I can try to put those links down below on what the final admission is, but it's a really important document because essentially what it is it's the insurance company basically trying to say, okay, this is the extent of what we're going to do. This is all we have to do, and if it isn't in this paper, we ain't going to do it. And so it's really, really important. Please, please don't wait until you have a final admission to try to find an attorney. Get an attorney on your side immediately before you get the final admission, because we're going to be able to take steps to go, whoa, preserve your rights, make sure everything's done. And furthermore, having an attorney on your side before a final admission of liability helps us steer the case, advise you how to present, how to complain, what issues to bring forward to the doctor, so that maybe your concerns are addressed then before a final admission rather than you trying to do it afterwards, okay? But the final admission is going to come, and you're going to need to review it, because if there's anything that isn't in there that you disagree with, or there's something in there that you don't think should be in there, or if there's something in there but you think you should have more, you're only given 30 days to do a number of serious things, and they're kind of technical. You've got to write an objection. If you disagree with the MMI, if you disagree with the doctor's impairment rating, you can do what's called a division IME. We'll talk about that later. To challenge those things. and then you start that process. And even if you agree with MMI, and even if you agree with the impairment rating, there are a whole host of other issues and benefits that you may say, I still need this. For example, there's a benefit for disfigurement. It's one of the most overlooked benefits in workers' compensation. You've got to get that started. Otherwise, within 30 days, you are stuck with whatever is on that final admission. And so final admission, very important in terms of taking the next step in terms of your work injury. Beyond that, frankly, you can lead your life, but it's a big, big point in time where people get very concerned with reason about what is going to be the impact of this injury on their life going forward. Almost number one concern is work issues. Can I work? Can I keep working? What if I can't do the work that I used to be able to do? And all of those are great questions. We're going to be addressing them when we talk about disability, because a lot of folks call me and they'll go, well, aren't I entitled to some sort of disability? Can I apply for disability? We'll be discussing that next week. But again, the last thing that happens after MMI is the insurance company should typically file a final admission of liability, and that's going to create on your end a need to do a lot of things quickly, which is why you need an attorney who handles workers' compensation. It's what we do. It's all that we do here at Kaplan Morrell. We've been helping injured and disabled workers like yourself, perhaps, or people that you know, since 1995. We'd be happy and thrilled to be able to help you. All our consultations are free, complimentary, and we only charge a contingent fee on what we're able to do to help improve your case. So as always, please give us a call at 970-356-9898 if you've received a final admission. Now, if you've instead received a notice and proposal from the insurance company because they want to fight what the treating physician has said, get with us immediately, because you're going to be confronted with a number of names of doctors that the insurance company will try to get you to agree with. And I can't tell you how often I've seen injured workers who they said, oh yeah, I agreed to Dr. So-and-so. And I'm like, why would you agree to that doctor? He's awful. Of course, I know these doctors. I'm aware of who's good, who's bad, who's naughty or nice. And I would never agree to those folks. And unfortunately, injured workers tend to think that doctors in the system are neutral, that they're unbiased, that they're going to be straight shooters. You, after all, are a straight shooter. The doctor should be able to take care of you. Not happening. There are doctors in this system in workers' compensation who are absolute players, partisans in the games, who do not have the interest of injured workers in mind, and you should avoid them like the plague, but you won't be able to if you don't know them. We know them. We can help you avoid them. And with that, please give us a call, 970-356-9898. Check us out on our link. Come talk with us. We'd be happy to help you. With that, thanks so much for spending part of your day with me. Bye.